Thank you, folks. Have a seat. And good morning. We're here in 1 CACV 220514SC, Julianne Skoglund versus James Dell Barbour II. This is time set for oral argument. You each have 20 minutes per side. You will argue now, as is tradition, from the podium rather than from the table. I don't think I have to cover the masks anymore, though every once in a while it comes up. The Council, if you wish to reserve any time for rebuttal, you will need to do so on your own. You're welcome to tell us, but we don't keep track of that time. The clocks do count down. I know you folks know that, but we cover all of these things regardless. As you're going through your argument, we are recording and broadcasting these over the internet. So please, when you approach the podium, state your name and identify the party that you are arguing for. With that, we have read the briefs. We have truly studied the case. And are looking forward to hearing your argument, and I expect it will be a little lively at some time. Mr. Berkshire, if you're ready.
May it please the court, Keith Berkshire for James Barbour, the appellant in this case. The main issue I'm going to focus on, obviously, is the ownership interest in VIP, given it the significance of the difference in the case in that, given that issue. Our contention at the trial court and on appeal is that these cases have to start with 25-214. This is the legislative directive that either party has the ability to manage, control, and dispose of community property. The same as 25-215 regarding debt. That same manage, control, or bind the community applies to all transactions done during marriage. So the issue here is, what are the exceptions under 25-214 or 215, such as the application of debt, fraudulent transfers, breach of fiduciary duties, gifts, torts, other exceptions to those statutes, or to that statute, because that statute is the starting point for this case. So what Appley wants to argue is that the gift standard, that a theoretical gift has a completely different standard than incurrence of debt, has a completely different standard than a tort, has a completely different standard than a fraudulent transfer. Our argument is that all of the exceptions under 25-214 have to have the same standard. Here, the trial court classified this as a gift versus being a business transaction. And one of the issues with this classification is that my client, as the technical owner of VIP at the time that this transaction occurred, he's no different than the business itself. Like most small businesses, like my law firm or any other small business, I am the business is me. How I conduct a business is somewhat irrelevant because it gets to a form over substance argument here.
Or are you saying we should apply the business judgment rule here then? I mean, are you saying that the marriage, if they're married, the community owns a business, that it's all subject to business standards?
I think that whatever the standard is, that all of the exceptions to 214 have to be the same. We agree that the business judgment rule has never been applied in a divorce context. It hasn't. Not that I've seen it. And
so,
however,
the community owns an asset. The asset is the business. Then there's running the business. They're two different things. So the community could own that asset and let somebody else run it, and have no involvement in the management, right?
Correct.
Okay, so isn't the issue, is it a gift of a community asset? And there may be a business reason for doing it on the other side, but just starting with, was there a gift under the marital law as opposed to business? Isn't that what we're dealing with?
Well, I think to some extent, yes, Your Honor, but however, we can't disseminate between, he is the business. There's one owner. I mean, let's take a kind of ridiculous hypothetical here, which is Jay calls a meeting of himself in his business office.
Is there only one owner, or is there a community owner? Is he the owner?
The community is.
The community so I think we should be clear, it's a community property.
Correct. However, like most small businesses, one person runs it. Like most divorces, one person runs the business. If they want to make a distinction between this was done as a business, Jay holds a meeting, does it through VIP, technically sells the share to Tea Garden for $1. Does a completely correct business transaction, buy-sell agreement, sells 31% for $1. Is there really a distinction between that, which was done as a business, not a personal through a gift tax return, which all the testimony was that this was done just from a gift tax return to do.
He still did it as a gift. That's the fact.
Correct. And we have case law that says how you apply stuff on tax returns, whether it's community or separate, doesn't matter. It's the form.
And that's what would happen if you had done the dollar deal.
Correct.
Could happen. Same argument could be made.
But again, if he
But
would.
let me ask you this. When we're dealing with this, how does the fact that she objected, this just isn't something he did. She said, don't do it. Is that a factor under fiduciary duty? Is that irrelevant? Is it different substantively from not consenting?
I think there's, the problem with that, if there is spouses object to expenditures all the time and they still do it. And if we get into, there's plenty of cases, I think it goes back to Porter, that says we're not going to do a reverse, accounting of everything the other spouse objected to. So the issue is, if that's the lesson out of this, that she didn't object and she specifically objected, then the lesson is to hide it. So to never actually ask permission is to just do it. Do it through the business, never tell her and just transfer it, because then she didn't object, which is what the court latched on to.
So whether she objected or did not, you're saying is irrelevant to whether there was a breach?
Yes.
Okay.
I mean, it's the intent of the transaction that always matters. When I look at all these exceptions to 214.
What if there's detriment, though detriment was not intended? How does that work?
Well, I think the area of law in this, the 214 case law, really revolves around debt. I mean, most of the case law that interprets 214, the vast majority is debt cases under 215, the 215 exception to 214. And all those cases that say there has to just be, even if it's not the primary purpose, that there has to be some intent to benefit the community. I mean, we can look at the tort case law. There's a case, I think it's Garrett v. Stevens, where the husbands in a case got drunk on a golf course and beat the heck out of some other people. And that was still held to be community because they're playing golf, which is community. So, and again, it was analyzed under 25-214 and 215 that there was, the action itself was intended to do something for the community.
Where in this record do we have findings sufficient that would allow us to come out for you showing the intent necessary in your client?
Well, I think the findings I think we go the other way, that there was no finding under the fraudulent conveyance statute that there was an intent to hinder or destroy. So if under 44...
What if there's a detriment and he subjectively intended to benefit? What do we do with that? We just say she didn't find a fraudulent transfer, so you're good? Is that what you're saying?
Well, I think, again, if the purpose, look at it if it was a stock transfer. I invested, I have a lifelong history of making good stock investments, and the day before Enron collapsed, I put our entire nest egg into Enron. Okay, well, I historically made good transactions. There was an intent to benefit, or at least there wasn't an intent to harm. Here, there's no question that there was an intent to benefit. He added a partner, and the court found, I think back to your question, Judge Jacobs, is the court found that but for adding Teagarden and his team in 2007, the business would have collapsed. They would have lost $1.5 million, their original investment. So
they had that benefit without the subsequent 31% gift, so where's the benefit in that?
Well, I think that same argument could be made of, adding doctors to a medical practice or lawyers to a law practice. You usually, most small firms, somebody works for them for 5 years, they make them a partner. It isn't a buy-in, it's a reward for essentially.
Actually, don't most firms have a buy-in?
Well, a lot of them, it's trivial. And
there are some associates who may disagree with that.
Represent a lot of lawyers. A lot of them have some, some pretty nominal.
But there was no buy-in here. There was nothing to beyond just here's 31%.
Well, but again, it was a historic contributions that were essentially the buy-in. Much like lawyers in a law firm, this associate made you all this money, and therefore then you're allowing them to buy in for some nominal amount. And so again, are we going to distinguish that this nominal amount is actually the transaction? A lawyer buying into a law firm for $20,000 when they get a $200,000 a year reward on it? Is that really equal?
So sort of going back to my question 2 questions ago, the benefit that you see that you would have us anchor a decision in your favor on would be that 7 years ago the business was saved and was grown and value was added, and so this is just sort of a reasonable quid pro quo within the business management of your client. That's the benefit you see in the facts.
Well, I think that there doesn't need to be a finding of a benefit. My belief is that the proper standard like debt and the fraudulent conveyance is that it has to be proven by clear and convincing evidence the other way to get around the transaction.
But there's 2 claims here. It's not just the fraudulent transfer. There's the fiduciary duty. And don't our cases say that you can have a breach of the fiduciary duty the non-breaching spouse has to prove a benefit to the transferring spouse or a detriment to the a detriment to the non-transferring spouse. Here, wife asserts that 31% was given away, and facially she has established a detriment. Isn't your answer to that, but that's not a breach, and it's a factual issue to determine whether or not, her having made that showing, that there was no detriment to, in fact, to the community, but in fact a benefit? Isn't that what you're really trying to argue? And I guess what I'm trying to get to is, let's say we buy your argument, don't we have to remand it and have the Superior Court make a lot of findings on this issue?
I don't think so, Judge. I think, again, we don't have a dearth of case law on this issue. And the two cases on this issue are Giroux and Mezzi. And those ones are so clear that it's not even questionable. The guy, transferred it to his sister-in-law. In Giroux, he transfers all of his clients to his sister-in-law's business and becomes, an employee. And Mezzi, he just gave all his money to his girlfriend. Okay, there's not even a remote argument that there is a purpose there for the community. I mean, essentially, those two cases could have been waste claims. They didn't even need to get into fraudulent transfer. They could have been waste claims because under 25-318. So the issue here is, what is the standard, again, for some type of transaction? No one doubts that Teagarden has worked for this company through today, 16 years later. No one doubts that he is a partner. No one doubts, even the court found, yes, he is a partner there. No one doubts that. So our position is that just simply any intent to benefit, which I don't know how there is a dispute that there was an intent to benefit, because the court found an actual benefit. So short of the court finding in 2007 that yes, it benefited, but there was no intent to benefit by bringing all these people over.
We're not dealing with consideration in a contract where we don't peek behind it. Here we've got a breach of fiduciary duty. So part of what we're dealing with is the extent of the benefit, and the extent of the detriment. There are other claims that were made here, or other gifts that were made in this, much smaller amounts. Isn't part of what gets us into this the fact that it was 31%? It was far greater than anyone else, and that's where wife at least gets to say, look, when you give away that much, and I don't know that we draw a line on where that much is, but at least they get to the trial court to decide that, and maybe the trial court says you're right, 31% was too much, but 5% was not too much, so we're going to take the 5% and say that was okay. I know that happened with at least one other person here. But then the other 26% is what we're going to divide. We're going to give the benefit to the wife off of. Would that be inappropriate in this case?
I think so. And I think so because, again, I'll go back to the debt case law on this. In Donato, when the Supreme Court talked about the rise of this debt, they talked about even if the debt gave no benefit, it's as long as the intent was to benefit, that is the issue. So in Donato, in the occurrence of this debt, again, the Supreme Court said, even if the debt, if the act which gives rise to the obligation, even though tortious in nature, was done with the bona fide intention of protecting the interests of the community, it becomes a community debt, even though no benefit actually occurred. And so I think this gets into the argument was the transaction commensurate? Our argument is that the gift doesn't have to be commensurate in value, and that's where we think the court erred, is that the court looked at, okay, did he prove that a dollar for dollar commensurate transaction, that Teagarden added enough value at that point after 2014 to justify that percentage? I think, again, it's the intention.
I struggle with that, because what your argument would lead to then is he had the intent, and the next day Teagarden took everything, including the 31%, cashed out and opened a competing business, took it all, and that would have been okay under your argument, wouldn't it? Well, because he had the intent.
I think that if it was a bona fide intent, people make bad business decisions all the time. I can add a lawyer that comes to my practice, takes all my cases and leaves. If I intended it to benefit, how did I know that this person had malicious motives? People make investments all the time. If I was
so why do you giving the sister-in-law? Why do you giving the sister-in-law? Wasn't that subject to a bona fide analysis then? These other cases you're suggesting we should have added an element before, which is, was there bona fide intent? Let's say it was a son that had the ne'er-do-well son who lived in the basement, and the the father said, I want to give him a third of the business, and the mother said, no, you know he's not going to do anything with it, and Dad did it anyway. He had a bona fide intent, he wanted to get his son involved, right? That good enough?
I think that, again, under the analysis of the Fraudulent Transfer Act, when it's to an insider like that.
There's two claims. Let's stay out of the fraudulent transfer. Let's focus on fiduciary breach.
But I don't think that, my issue is, I don't think that we can ignore that how these interplay. I think that the fraudulent transfer is the fiduciary breach. I think that it is the transaction. Whether we call it a gift for form over substance, we're going to get people into, again, let's do an actual business transaction versus calling it a gift for tax purposes. We get gifts for tax purposes all the time.
Well, I guess my struggle is, our Supreme Court has told us there can be a fiduciary breach in the marriage and doesn't necessarily, has never suggested that it needs to meet the fraudulent transfer statute.
Well, again, the case here is the intent of the party, is the intent, a bona fide intent to do some benefit here. And there's no question in this case there was a bona fide intent to benefit the community by bringing Teagarden over, because the court found that there was a benefit.
But he was already over. You keep saying that, but that was in 2007. This is 7 years later. So, and there's no testimony or evidence that I saw that this was a way to keep Teagarden. Well, Teagarden said, I would have left had he not done this.
There was. Teagarden discussed that but for being a partner, he wouldn't have stayed. And these people that, again, he brought over two of the top 100 loan producers in the country with him that stayed because of him. So I think that's the wrong.
So isn't that evidence the court should consider and decide? And I apologize if I had. You folks should know the record better than I do. But if that's the case, isn't that what the court needs to weigh out? Under the right standard.
No, and yes, under the correct standard of the intent, yes. Okay, because again, I think the intent of why you kept him versus this concept that this isn't a gift to the Humane Society. This isn't I gave away 30% with no conceivable benefit to the community. This is, what is it? This is, I kept a partner around for the course of 16 years that took us from $1.5 million investment to an estate pushing 9 figures.
And counsel, where was the testimony that you just had that colloquy with Judge Goss about?
I know I cited in my brief that talking about this. I believe.
Okay. I just didn't remember.
I believe. I can check, but I believe there was testimony about that. I'm not sure it was cited, but I believe there was. The issue here again is what was the standard at looking at? We think that I'm not sure how we're going to get into semantics about the difference of how a transaction occurred if we do it if all these exceptions to 214 have different standards. So that's why I think that they have to have, if we look at the ones that we know of that are very well settled versus just two cases like Mezzi and Giroux, which I believe also support us, with the debt law, the tort law, these other actions have some other intent to deprive the community or not to benefit the community that I think has to be there. And so I think that that's what the standard needs to look at. And any exception under 214 has to look at what has to be under the same standard. Because the gift standard the court used here, even though there's no question that he was involved in the business, the court looked at it as if it was completely non-business related. It was just simply she didn't consent, it was substantial, too bad. People, like I said, people add law partners, people give bonuses, people do all these things all the time. Just because I write a bonus out of my business account versus my personal account, what's the difference? If I personally, Berkshire Law Office do that, there's no difference. I control it 100%.
But that's the difference here, because he doesn't control it 100%. They both equally control it. So we've got a slight difference in looking at how
I'm
you
married.
do that.
The argument, my wife could make the same argument. But again, it's from a business standpoint.
Especially when she says, and don't do this, Mr. Berkshire, and you do it anyway. Doesn't she get to follow through on that she disagreed with you? You're saying no, she just loses.
Well, she didn't lose. They put $1.5 million in and got a $100 million estate. I don't see how she lost. So, I mean, this isn't somebody who she said don't invest in Enron and you've invested in Enron. This ended up with an enormous business.
I guess that's what I come back to. That's the damages issue that the court needs to look at and say, who proved damages? And in this case, your client, the court made a finding, and it said, I'm trying to find it in very small print.
You probably look at paragraph 62.
I think that's the one that I'm just not finding it here.
Paragraphs 18, 61, and 62 are the ones that
Husband also failed to present credible evidence, we defer to courts on those things, credible evidence to show the community received any direct or indirect benefit in exchange for the 2014 gift to Keith, which occurred several years after he joined the company in 2007. I struggle with now, again, coming back to one perspective, which is this is a damages issue, and the court made a finding that your client didn't meet his burden of showing that there was, in fact, a benefit to the community. How do we say that that is an abuse of discretion as opposed to what you seem to be arguing, an error of law?
Well, I think, again, the application of this is some independent gift, irrespective of its involvement in the business, is the error. That you have to go down from 214 into all the case law that has similar standards. But I think the paragraph before what you stated, Judge Goss, where the court says, husband didn't present credible evidence to quantify the value Keith brought to VIP or to show it was commensurate with the value of what the shares. And I think that's the issue. That gets into this argument that it has to be commensurate, which flies in the face of Donato, it flies in the face of Cadwell, that somehow it has to be, I have to have, a crystal ball knowing that I'm going to get an exact value out of this.
So, counsel, this goes back to the question I asked like 13 minutes ago. I think basically what you're saying is that there was benefit, and the court's recognition that there wasn't sufficient benefit can be read as a finding that there was some benefit, which means the court is referring back to your theory that 2007 and the run-up was the benefit. That's what you're saying, correct. And that's where you're grounding it, right?
Correct, which is, okay. like I said, like law practice, medical practice, all these people that essentially earn their right to buy in at a nominal fee. And I'm out of time.
All right, thank you. Counsel? You may have gathered that you have a bench that's excited to talk about fiduciary duty here today.
Me too. Glad to hear it. May it please the court, your honors, my name is Eric Frazier on behalf of the appellee, Julie Skoglund. Gifts, your honors, are a major problem in family law, and that's why there is a special rule for gifts that is different from things like fraudulent transfer, different from things like the business judgment rule. It is so easy to say, well, I don't want my spouse to get this asset, so I'm going to give it away to a friend or to my child or to my brother. That's why this special rule exists, which is well established in Arizona and elsewhere. And what's really at issue here is whether the trial court was allowed to apply the well-established doctrine around fiduciary duties, or whether instead the court was required to apply doctrines like fraudulent transfer or the business judgment rule. Husband does not actually challenge the application of the trial court's fiduciary duty. He doesn't challenge the sufficiency of the evidence supporting the trial court's factual findings on this issue. He keeps telling you that this was adding a partner, like adding a partner to a law practice or a medical practice, but the trial court disagreed, and this is why we have trial courts, to make these findings. The trial court found that this was not a business decision, this was not adding a partner, this was a personal transaction, a personal gift. Now, other people might disagree. Some of you may disagree. Husband obviously disagrees, but this is why we have trial courts. The trial court is charged with making the factual findings to determine whether this was a gift or whether it was a business transaction.
So I want to just make 2 points. My review of the record, I think our review shows that this was never alleged as a waste claim. So there is no claim that this was waste.
I believe that's right. It was alleged as fiduciary duty and fraudulent transfer.
The second question I have ties into what I asked Mr. Berkshire. Do you believe that the fraudulent transfer claim, and I believe your client brought that as a separate claim, is different in kind than the fiduciary duty claim, and if so, how?
It is a separate claim, a separate doctrine. If you look at Measy, you look at Giro, they're applying them separately and independently. As we said in our briefs, oftentimes the same conduct would satisfy both claims. Our position here below is that the same conduct does satisfy both claims, but the court only needs to make findings on one, and either one is sufficient. The fiduciary duty claim, this is a claim unique to marriage. It's unique to family law. It's the fraudulent transfer statute applies to all sorts of claims outside of marriage, so it's not surprising at all that we would have these two independent doctrines, one of which is rooted in the Supreme Court's common law finding that there is a fiduciary duty between spouses, and the other one, of course, is grounded in statute. But the common law fiduciary duty claim is well established in the law. It's recognized by multiple treatises, 2 cases from this court, cases from other jurisdictions. This is well established in the law because it recognizes that gifts are particularly dangerous in family law. They invite mischief because this is one of the simplest ways to try to protect an asset from your spouse.
Hey, counsel, could you please help us a little bit with the relationship, if any, in concept between fiduciary duties in the context of the marital relationship and the fact that we're dealing with a business asset here, and the relationship, if any, between, or analogies between fiduciary duties as applied to a husband with a wife who's not a partner in the business but is in the community, and businesses where there's a minority shareholder. Can you compare those contexts and how the decisions play out?
Sure. So there's obviously a lot there. I could spend the next 16 minutes talking about it. I'll try not to. I'll start with something that is probably obvious, which is the trial court can distinguish between giving away an asset owned by the community versus giving away an asset that is within the corporate walls. So that's where we start. And obviously here, you know what I'm going to say. The court found that these were shares given away by the community, these were not treasury shares or new shares issued by the company. So there is a distinction. Different people, different fact finders may make different findings. This judge made a particular finding, and husband is not challenging that finding.
So if there had been shares and the company had just given shares away, would that be a different case then?
I think that would be a tougher case. I'll be the first to admit that it would be a tougher case. I think there is definitely support for the notion that the fiduciary duty does not end at the corporate walls. And we see that in this case as an example with, I think it was Inventive, which was a new company that husband created to take the IT systems out of VIP, put them into another company, and essentially siphon off of the money. So VIP starts paying Inventive Technologies, husband gets paid from there. The trial court here found that, number one, that was a fraudulent transfer, number two, that breached the fiduciary duty. And so, and then there was another finding as well. But as to the fiduciary duty, that was a transaction that occurred within the corporate walls. It was taking an asset of VIP, moving it outside of VIP, and the court nevertheless found that breached the fiduciary duty.
So do you have a case that's outside of this case where somebody, perhaps an appellate court, has reached that same conclusion?
Not directly. Again, I think the reason there is because there is often substantial overlap between fiduciary duty and fraudulent transfer. Again, in the example I gave you from this case, the court made both findings. I think the closest is probably Giro, where it was a situation where the husband, or not the husband, the husband's sister-in-law incorporated a new separate entity, and the court nevertheless did a partial unwind of that transaction. That's not all fours with the hypothetical you're giving me. I don't have a case on all fours. But I think, again, you can think of a variety of situations. Let's imagine that that you have a company and the husband gives away, or let's say the company has $30 million in cash and the husband gives away $25 million from the company's treasury to, his favorite stripper or his son or his girlfriend or any example like that. I think the fiduciary duty doctrine would extend far enough to say that a court would have discretion to award an equalization payment. Because we're talking about equalization payments. We're not reaching into the company and interfering with the company. We're just saying that because of husband's conduct, the wife is entitled to still have her half of the community.
So what if it was a much significantly lesser amount, $10? And what I'm thinking of, $25 million sounds like a lot to most people. But to a multi-billionaire, maybe not. That's just, yesterday's tip.
Wouldn't that be nice?
And it would be a unique existence. But so is really the issue here that it was 31%? Because I'm looking at the others that weren't challenged.
Yep.
5%. So coming back to the question that I asked them, is it a factor of the amount? And could the court then, and should we send back to the court, say, you have to look and say, what was the appropriate amount? If, has anyone shown what the appropriate amount was? Was 5% okay? Was 10% okay under the circumstances? And then look at the equalization payment under those circumstances, as opposed to just 31%, we're going to basically claw it back through equalization.
So let me answer the second half of your question first. No, I don't think a remand is in order here because husband never raised any of those claims below. He never said, oh, you can reduce this and instead of awarding 30%, just give her 5% or let me keep 5%. He never made any of those claims. So the Superior
We
Court...
articulate a new standard. Shouldn't we send it back and let the trial court work with the new standard?
I suppose if you articulate a new standard, I don't think that's the appropriate standard. The word substantial here is doing a lot of work, and this is the answer to the first part of your question. This is the quintessential thing that is within the purview of the fact finder. Was this gift substantial? So it doesn't cover, ordinary gifts to, your church or a charity or a graduation gift to your niece or nephew. It doesn't cover those things. It covers substantial gifts because that is where the mischief occurs. And in this case, we have consent sought by husband repeatedly with a gun to wife's head. He seeks consent. She tries to get a lawyer, has to beg for $3,500 for a lawyer. He then makes her fire that lawyer because it's ruining their marriage. She has no protection here. She stands up for herself, holds her ground, refuses to consent. So we have consent sought, consent refused, and then surreptitious signatures. The court found that this was...
factors that go into deciding whether there was a breach, because what if those factors weren't here? Would wife still have a claim? Let's say husband just never told her. He went, said, okay, Keith, sit down, we're going to sign this off, and just did it. Would wife still have a claim?
I think under the doctrine, the answer is yes.
So there's some factors that might support
which is
argument, but they're not necessary.
They're not necessary because those are the types of things that a trial court considers when exercising its discretion to apply the doctrine. Again, this is why we have fact finders, particularly in the divorce context, where the division of assets is supposed to be equitable. We're trying to do equity here. We give a lot of discretion throughout family law to the trial courts to do what is equitable. And I don't think that a situation like this calls for evaluating a damages claim. This is not a damages claim. What Measy tells us to do is if you breach your fiduciary duty, you set aside the gift. You act as if the gift had never been made. And husband here knew what he was doing. He knew that he needed her consent. He held a gun to her head. And then when he didn't get her consent, he did it anyway.
Well, he certainly saw her consent in offensive ways. I don't think that demonstrates as a matter of law that he, quote, needed the consent. I'm a little troubled. I'd like to take you back to the last 30 seconds we had with your opposing counsel, because the thing I'm on is whether there's value here. And in paragraph 61, it's not like the court is saying Teagarden brought no value. The court is talking about whether, husband didn't put in sufficient proofs to show the quantum of the value. It seems to presuppose Teagarden brought a lot of value. Do you agree that he did?
I don't think the court. I think that my recollection is that the court found that the community received no value from this gift. This is not a question about whether Mr. Teagarden benefited VIP. The question...
I'm sorry, let me just pause you because I want to make sure I understand this right. Paragraph 61, husband did not present credible evidence to quantify the value Keith brought to VIP. Presumably, if husband had presented credible evidence to quantify the value Keith had brought to VIP, that would have been significant. So in paragraph 61, which I think is arguably very beneficial for you here, right? Like there's a discussion about the value that Keith brought. And so I think in our prior discussion with Mr. Berkshire, we're troubled by the fact that it was like 7 years ago the value showed up, and gosh, is that really reasonable? But do you dispute that Teagarden added value? Because that's his best point in a way. So I'd like to know what you think about that.
Sure. What I think about that is paragraph 62, the very next paragraph, where the court says, husband failed to present credible evidence to show that the community received any direct or indirect benefit in exchange for 2014 gift of shares to Keith. So that's the finding, and that's the finding that has to be clearly erroneous to reverse.
Is that not contradictory with other findings? I mean, that was part of counsel's point, is that you take this $1.5 million asset, the majority of which was, actually all of which was owned by the community to begin with. After the gift, the majority of which is still owned by the community, and increases from $1.5 million to $88 million. How is that not an increase of value?
Because the court made a finding that that increase in value was not attributable to the gift.
Right.
Again, I think what you're struggling with here is the very natural reaction that maybe if you were the fact finder, maybe you would have found this wasn't a gift, this was really a business transaction. We're going to treat it like adding a partner, and if the partner added a bunch of value, well, you have to figure out what that value is. That's not this record. That is not what the Superior Court found. The court failed to present credible evidence to show that the community received any direct or indirect benefit in exchange for the gift of shares. So that's paragraph 62. So you read paragraph 61, where the court is saying, yeah, Mr. Teagarden provided value to VIP 7 years ago, but in 2014, no benefit.
Isn't that the whole nub? I mean, you win if the trial court was right to atomize it. And there's like sort of a legal doctrinal way to run that, and there's like, oh, it's fact findings defer to it way to run that. But I mean, you win if we atomize the analysis, and if we don't, it's a little more difficult, right?
Well, I suppose, but again, I think for husband to prevail, he has to get you to reverse that finding in paragraph 62. The paragraph 62 finding, he needs to show that that was clearly erroneous. Not maybe wrong, not probably wrong. You know, we put this quote in our brief that it has to reek like an unrefrigerated, dead 5-week-old fish, right? That is what he has to show, that the finding that the community received, or that there was no credible evidence that the community received any direct or indirect benefit, none. And so that's the finding that he needs to show that's clearly erroneous. And I think what you're struggling with, obviously paragraph 61 at first seems like it's intention. But as you say, when you look at it and look at what the doctrine is doing, you're saying we're not looking at this from VIP. These were not shares from VIP, these were the community shares. He needs to show a benefit to the community. And there's no evidence, for example, that the shares had a normal vesting period, like you might see if this was actually designed to attract and retain talent. You would vest them over 4 years, or it would be a bonus for past performance. This was a gift. You know, the court found that this is not adding a partner. He keeps telling you it was adding a partner. A different fact finder, maybe a different fact finder, could have found this was adding a partner. So this judge disagreed.
Paragraph 61, and I unfortunately do not have it in front of me, but the key language, and you had read it, is that husband did not, 61. The evidence showed that where's the value piece? Oh, it's the first sentence. The court does not find that Keith contributed value to VIP by bringing his team, the court does find that he contributed value. So if the Superior Court was wrong in not weighing the value that VIP received, and I'm just saying, again, you're drawing a line saying don't even look at VIP, stay within the marriage. If the standard should be or is articulated as looking at the value of VIP and seeing how that affected the impact on the community, don't we have to send it back and say to the court, you didn't use quite the right standard, you made 2 findings that we need you to resolve and figure out how that works? And I know Mr. Berkshire said no, or you had said no, we should not send it back, it's all or nothing. But when you look at it from that perspective, and I hope that makes sense.
It does make sense. So I'll tell you.
So go ahead.
I'll tell you, if that is your holding, if that is your ruling, then it should possibly be sent back. I do think there's a very serious waiver argument that husband never made that argument, and so this court should be limited to the arguments he actually made in the opening brief. He's not saying you should remand for, he's not asking you to invent a new standard under the fiduciary rule. He's saying the fiduciary rule essentially is no good, right? And you shouldn't apply it because you need to apply these other statutes. So because he never made that argument, I don't think you should remand. I think you should affirm, even if you articulate a new standard. But I suppose, if you disagree with me on that, then there could be a remand. But again, under the current standard, under the current doctrine for fiduciary duty, which has existed for a very long time, that's not the analysis. The analysis is if there's a gift, then you treat it as if the community still owned all the shares. And you don't look at value, because this is a gift. A gift, you're not, by definition, you're saying you're not receiving value because you're giving it away. There's no, it's almost antithetical to say you're getting value from getting a gift. You don't value a gift. You just treat it as if it never happened. You don't put a valuation on it because you're not receiving anything in return, or you're not supposed to. He tells the federal government, I'm giving a gift and I got nothing in return. He tells the federal government that in his gift tax return, and now he's asking you to do something different. I mean, we don't do that. And that's not, by the way, that's not the only evidence that this was a gift, right? It's not just about the tax returns.
Well, counsel, assuming that we were to step past some very sound arguments that we can't step past, the conceptual category gift, I'm still a little unclear on, and this is a very naive question for which I apologize, like, what's the difference if we look at the form and the substance instead of the form between wife here and a minority shareholder in terms of how fiduciary breach law would apply to an analysis of this transfer, assuming it's a business transfer and not a gift?
And counsel, I'm just going to tell you, I'm going to give you an extra minute, and I'll give Mr. Berkshire a minute for rebuttal.
Okay, I appreciate that. So I think there's an important difference, which is that this is family law. And again, the danger of gifts in family law is of a different kind than you would have in a minority-majority shareholder situation. That's why this doctrine exists solely in family law, I think, is out of recognition that giving your assets away to your long-term friend has very serious risks for inviting mischief. And I think that's the answer, is that it's a different body of law, and it's a different body of law for good reasons.
So there really could never be sort of a, was it prudent in managing the community's asset to do this analysis? It simply comes down to whether it's sort of like a stalking horse for waste, it sounds like, in terms of just dissipating, because a gift it's not a waste claim, but you're sort of conceptually calling it waste is what I'm hearing.
Well, because again, there are lots of different doctrines that could apply here. Waste could apply, fraudulent transfer could apply, fiduciary duty can apply. Yeah, and breach of the fiduciary duty can apply. I think in your example, if you have a minority shareholder and you have the majority shareholder who, again, gives away 31% of the value of the company, that seems a pretty clear breach of the minority shareholder's fiduciary duty. It would violate the business judgment rule. It may be a fraudulent transfer. So I think even in your hypothetical with the minority shareholder, you can't give away 31% of the company's assets.
No, I completely get where you're coming from, counsel. And again, it goes back to what I said earlier, which is if we atomize the analysis and it's an analysis of the day of the transfer, like you win running downhill at 100 miles an hour, and if we look at the value language in 61 and see an ongoing business management relationship and see this as a business transaction, you might or might not win. That's kind of where I'm sitting.
Which is why I want you to focus on paragraph 62, which is the important thing. That's where I'm going 100 miles an hour downhill. I appreciate that analogy. I will say that, again, going back to your hypothetical of the minority shareholder, majority shareholder, imagine we have a company, you have that hypothetical, those shareholders, and the company, again, has $30 million in assets, and the majority shareholder gives away 31% of them to his friend. No matter what, the minority shareholder is going to have a claim. And that claim will probably result in setting aside that gift, not trying to figure out how much value did his friend make, how much value did his girlfriend make when she was employed for a week and got a $25 million paycheck. The analysis will be to set aside the gift. That's what Measy tells us to do. That's what this court tells us to do. And even once you arrive at the conclusion that there was a fiduciary breach here, the ultimate decision of how to divide up the community property is evaluated for abuse of discretion. And so that is within the court's discretion. So I don't think a remand is appropriate.
Thank you.
Thank you. And thank you for the additional time, Your Honor. I appreciate it.
So does Mr. Berkshire, I suspect. At least you get 60 seconds.
Since I had 0, that's better. Paragraph 65 also goes back to paragraph 61 as well, that talks about this, was it commensurate under the business judgment rule. Court talked, he didn't show benefit to the community tied to equivalent values in the shares that he did. So again, I think it presupposes this concept that there was a value. We have 2 paragraphs that says that he just didn't show commensurate value, which then, again, if it was 0, I think it would be a different argument here. But I think the standard, if the court was going to send one back, is another error of the court is that this has to be value after 2014. Or at 2014 forward, and what's the time frame? What if they would have got divorced in 2015? The idea is that he added value at some point. I think if the court was going to do that, not just 2014 forward here, which is what the trial court focused on. They didn't focus on any value added prior versus they just focused on after, which again, using law firms as an example, you use your associates to make you a bunch of money and then reward them with a partnership, usually at a lower interest. But they made you value before you offered that, which I think is the same situation that has to be looked at here for the proper time period of when the value is added. Thank you.
Thank you, counsel. We've enjoyed this argument, actually, and we usually do. And we will take the matter under advisement and issue our ruling in due course. We are adjourned.